Welcome to Robots in Depth. Today I'm honored to have Linda Thayer here from Finnegan. And we're going to talk about the fact that when you start a robotics company, IP, patents, and the legal side is something you must really care about and really focus on. I know that you're all busy doing the development of hardware and software, but do not forget the IP side. Do use a good contact there, and she's going to tell us all about how to do that properly. Welcome.
Thank you for having me.
Yeah. Usually this would be a new area to a startup rather than an established company. They probably already have somebody dealing with this. So say I'm a startup, I'm maybe a PhD student, and I have this great idea. And my professor, who is experienced, says that this probably has a value, so I'm going to start a company. But I've done nothing, I've done my research, and I now come to you. What would the process be of what would you advise me to do, milestones to hit, and how to carry on before and during the startup of the company?
Well, I like your assumption. You said I come to you very early in the process. That's not often the case.
No.
Yeah, very often in many startups, also in the robotics community, the idea is so exciting, and the company or the individual starts building the product and starts wanting to get funding, and they go very far down the track before they have really addressed IP. And if there's one message that it could be, is exactly what you said, is really try to involve some IP counsel earlier in your process. I do know that, with startups that often it's the time versus money trade-off. They really want to get a product underway, and they often do not have funding, and they think of lawyers as the scary, expensive component to the whole process. And but that can be a problem, and could be short-sighted. I think if a new startup at least consults with somebody early in the process, they can help you outline the steps so that you don't miss any critical deadlines or blow your opportunity to patent before you even start.
And I think that also, as you say, this is a very stressful time for somebody starting, and as you say, lawyers can be expensive, but I think it's a very expensive mistake of avoiding this, because it can really be a problem down the line. I would presume that most investors would require a strong IP protection of whatever they're investing in, if that's patents or trademarks or anything like that, because otherwise technology is too easy to copy, in my opinion. Right?
That's absolutely right. It's funny, even earlier this morning I was working with one of my clients on putting together some information for their investor. And the questions that they asked are, have you applied for patents? If so, on what subject matter? How did you decide what subject matter to put in your patent application? Did you do a prior art search to see if there was prior art search in this area? Have you researched the market to see who's already a player? The prior art search component is important because for two reasons. It lets you know what's already out there. It might help you design around somebody that's already out there. And also it may expose some opportunities for development. If you find that there are no patents in this area, no companies already working in this area, it might expose some nuance that you can add to your application that would make your technology even more valuable.
Yeah, and also kind of start to claim your space in an IP sense. This is where you give us a timeline.
Yeah, I think the very first juncture to consult somebody is maybe when you have an idea, because I would recommend that you do this prior art searching and you do an industry search to see if it's an idea that you might be already preempted from doing development in that area, and I wouldn't want you to spend time and resources going down a path that's foreclosed because it's already covered. So that's a period. But say you don't. Say you start down the path and you have a product, or you have an idea and you start to write it up or think about it. I want you to come to a patent attorney and take some steps before you disclose it to the public, before you disclose it to potential investors. even to, my recommendation would be to write your ideas yourself in the form of a long technical paper and file that as a provisional application with the USPTO, the Patent and Trademark Office. That acts as a government document that tells that it's not disclosed right away, but it acts as assurance that you had that idea as of that date. It acts as a priority date, is what we call it. And if someone comes along with the idea after you and registers after you, it sort of saves your place in line, and it's, the government would know that you had the idea first. You can also then disclose it to investors and others because you have put your stake in the sand and you have reserved your place in line. I would just caution people to not disclose more than what they put in the provisional,
Then
and
they
that's
have to
the
add
danger.
another provisional covering what they want to disclose, right?
Exactly, and that would be my third piece of advice is that, you know, once you do file a provisional, you have to be diligent about if you have significant additional research or additional ideas. I would advise a client to file a supplemental provisional. And keep also the 1-year deadline in mind from the first provisional, because you need to convert the provisionals to an actual utility application before the end of the 1 year.
Okay, so it's called the provisional?
Yes.
It's called the provisional patent. Could you say the title so people could Google for it?
Yeah, provisional patent application.
Provisional patent application. And say that somebody comes to you and it's not an overly complicated idea. Can you give us a rough estimate on the cost of that? If they come to you and they want you to help help them to file this because they don't feel comfortable with the legal side.
Right. So the great thing about a provisional patent application is it doesn't have filing formalities and other things that require a patent attorney to write them. So we have done everything from the low end of the scale where a client has written and done all the drawings and prepared the provisional patent application, and we review it to just make sure that there's content in there and get it on file. The filing fee for a provisional application is less than $300 for a large company and less than $200 for a small company.
Yeah, so we're talking in the few $100 range.
For the official filing fees, yes. And then the costs are going to depend on how well written the provisional is.
Yeah.
I have had some people come to me with a document that needed significant help, in which case you then are paying an attorney or someone an hourly rate to help you. I have also had people come to me that was a very well-written document, and I was able to file it with minimal review time, and that's of course the low end of the scale. But so assuming that you write a good document,
an average one,
you
whatever.
could get a provisional on file for under $500.
And that's probably very well invested $500.
It's a very well invested. And if you absolutely have no amount of cash at this time, like I said, the filing fee for an individual is $160, I think, or maybe $180. And you can download the filing sheet from the USPTO website and file it yourself.
My opinion. So they've done this now, and then they found out, we need to add this little idea. They could do the supplemental then.
Exactly, and you pay another filing fee, you file another document. But I'd like to add one point to what you were saying earlier, is I do agree that you sort of get what you pay for, and there is some value to consulting legal advice. Sometimes what I find is that people write their documents more as a marketing document, and they talk about with functional language as to what they hope to do, what benefits their product will provide, but they don't really explain enough of the technical details. And the law the patent law in the United States is really changing such that the Patent Office is requiring more detail, more explanation of how you're different from the other things that are out there, down and what technological improvement your invention brings to the field. And if I can say, when people write provisionals themselves, I don't think they focus on that level of detail And I would, that's the review, what the review of a patent attorney could bring is maybe to point out the degree to which you need to add technical details in order to ultimately make your patent application successful at the patent office.
So don't be afraid of the technical details in this stage, and everything you add into is protected then if you go on to file for a proper patent.
Exactly, more is better.
Yeah, and you don't need to sell the idea to the patent office. That's what you do to your investors and customers, right? So they need to know the technical side, and the sales pitch can be kept for other documents.
Well, some of the sales pitch would be useful. I mean, the type of statements that are good for a patent application is what improvements in terms of speed or economies or just amount of data that you have to store or the price of the invention. If your invention improves in those types of categories, then I would mention that because that helps make the invention ultimately patentable. So that if you call that marketing advice, some of that is good.
Okay, now we know a bit more about that, and I guess there's also tutorials online and examples where you point out the good stuff and the bad stuff and all that. So then we have a year, and during that year we then have to prepare a proper patent application, and that takes some time because we have to start basically ahead of time before we have this deadline, because then we have to submit this proper patent application. How long time do you think we should say to prepare the final document?
Well, we estimate that it takes between 30 and 50 hours of a patent agent or patent attorney drafting time. So, and we don't work 30-hour days.
No.
Although sometimes we might need to. So you need to factor in the fact and back it up, a couple of weeks or ideally a month before your filing deadline. Of course, the provisional application is not examined. So there's nothing that says you have to wait for the year in order to get this done. And if you're interested in getting a patent sooner or getting an actual utility online, then I would advise you to begin that process sooner and not wait the full year. There's also some accelerated procedures before the patent office that you might want to take advantage of to try to get an actual patent sooner if that's important to your market. Maybe you already know there's people out there that are infringing and you want to be able to stop them to get market share, or if your investors really want to see that the tires are kicked and that the patent will be successful.
Because there's a big difference between an application and an actually granted patent, right?
There's a big difference between a provisional, which is a placeholder, a utility application, which is I've filed for it, but I don't know if I'm going to get it yet. Although you can say patent pending, and investors do like to see that you've at least made that effort. And there's a big difference. Of course, a granted patent is
that's the end product of this process.
Exactly.
Yeah, and so then we talk the utility patent. Is that that's when you submitted for a patent, but you haven't been granted it yet? That's when you can say patent pending.
You can say patent pending when you have filed for a utility patent application.
Okay. And then somewhere down the line, you get granted a patent, or they come back with comments and saying, what do you mean here? And so the whole process has to be, does the patent office come back to the inventor and say, this isn't clear, you have to improve the application? And how long time does this usually take?
Okay, well, you cannot make a application more clear, because the application, when it's filed as a utility application, has to be complete and clear on the day you file it.
Okay.
You cannot amend that at all.
So there's no second chance, right?
No second chance. If you do, you would have to file a second application, add more material, but then you get a second filing date, and we call those continuations in part. So it's possible to add the material or make something clear in that way.
But the new part will be covered from a later date. So if somebody added the new parts,
if somebody snuck in there in between you two, then they would have priority over the added material. Now, you can, it is common for the patent office to reject your application. Now they're rejecting your claims, and you can make the claims more succinct, more specific, more narrow, to more accurately describe your segment that you want to try to get a patent on.
Because you can't just patent everything, and too broadly then they say, well, this would patent pretty much everything, and you have to patent a specific idea.
Exactly, and that is where a patent attorney can be very helpful, and I would say is needed. The claims are very specifically written. They have to follow the format by the patent office, and they have to be narrowly tailored to carve out your invention or accurately describe your invention. And if not, it'll be rejected, or you may get a patent that is too narrow and is ultimately not worth anything, because nobody would make the product the way that you've written the claims. Or it may be ultimately, even if it's issued by the patent office or granted by the patent office, it could ultimately be unenforceable if the claims are too narrow. So you want to make sure that the claims are written with the exact scope that you want.
Okay, this is probably a very scary process for a young entrepreneur or any entrepreneur, but I guess this is also why having a good partner in this is essential. So now the company has the patent. They've been granted a patent. And they've used that and other resources to acquire funding, and they're about to launch or have launched the product, and then they find that somebody is infringing on them, or they believe that. Then they come to you and say, look at this guy, he's making something looking virtually doing what we do. What's the process then?
Well, in that process, they would consult us and say, I have a patent, this guy or this company is doing something we think is close. And they ask us to evaluate it, because it goes back to the claims. Is there any interpretation of what they're doing that falls within the scope of the claims? Now, sometimes at the engineer level, they see a product that on its face looks the same, but when we scratch beneath the surface, they are doing an implementation detail, a design around that does not fall squarely within the claims. In that case, we might suggest to the patent holder that maybe that type of product is described in your application and you're entitled to that, but the claims don't show it. In that case, we might have some strategies for getting claims to that. You cannot, if they're already doing it, it's public, so you can't add it to your application. However, this goes back to a well-drafted application. When you're drafting your application, we recommend that you not just limit yourself to how you are building your mouse, your mousetrap, but think about improvements, possible deviations, how somebody might design something slightly different. It's not because we're trying to get too broad of an exclusionary right, but engineers sometimes think only of the way they're making it today, and then we file the application and they say, well, we did it using A because that's what I had in the lab, but we could also make the same thing with the same results using B. And so before we file, during the drafting process, we engage with the inventors this way. I see you've built it this way. Are there alternatives that would achieve the same results?
And let's add those to the application.
At the application before filing. So it's possible, though, that we could have claimed the first way of doing it, the way they built the mousetrap. But in the description, we've described this alternative way, in which case we can file an application. It's called a continuation or divisional on that second way of doing it, because we described it.
Ah, okay.
Yeah.
What dates would then we apply if we add that, the continuation? Would it be the original date, or would it be the application, the second date? So
the original date, which is the argument for trying to put every possible alternative and every possible combination of components and all the ideas that you have in the one application, because we can go back to them and you can get patent protection on those ideas to the extent they are described in the original application.
And then we get it from the first date.
And from the first date.
Because the calendar is very important in the patent world, with the dates and the timelines. And so now we have the opposite problem. Somebody's claiming that we infringe on their patent. And what would I guess this is probably a more critical part for a startup, because they're not going to go out and sue people. They're busy trying to deliver to their customer. But if they get sued, that's an absolute. They have to defend themselves.
Right.
They can't really choose the timeline there then.
Right.
So they get a nasty letter. They come with a letter to you, and what would the process be then?
Well, there's two ways to combat a charge that you are infringing somebody else's patent. Either you come back and say, no, I'm not, and you have to have support for the fact that you don't. Or you say, while your patent is granted, we think your patent should not have been granted. And
we've seen a lot of that in the computer industry.
Absolutely. So, as I was saying earlier, sometimes on the face of things, it looks like something is falling within the scope of the patent, but when you scratch beneath the surface, you're doing it a different way than the way they claimed. And so a fair amount of the time when somebody sends a letter to one of our clients, we are able to know the details of our client's product and go back to them and say, you think so, but it only looks like that's what's happening on the surface. Here's some detail under, there's a agreement that we can sign, a protective order. We can exchange information to show them that little bit of information that they need, and sometimes they will go away. Sometimes they're more persistent. Sometimes we disagree on whether that falls within the claim scope of the claims or not. And then in which case we will then also do a prior art search and see if there's some arguments that we can go to the patent office with to ask the patent office to withdraw the patent.
Because the patent that was originally granted by the one that's suing the client was not really patentable to begin with, right?
Right. I mean, the patent office does a very good job of examining and trying to only issue valid patents.
But it's a very hard job.
It's a very hard job. There's a lot of information out there. And the examiners do not have, in my opinion, adequate time to do a complete and full review. And not like if you're faced with a litigation, it's possibility of taking down your company. You're very focused on that search. So we are often able to find prior art that we can go back to the patent office and say, hey, you missed this piece of prior art. No harm, no foul. But now we want to see if you could withdraw this patent.
Yeah, and also because we've seen some software patents when the idea they managed to get a patent on are so obviously simple. I mean, it's like patent water or air or something. We've seen that happen in the software industry, and that's led to a lot of problems for the software industry. But that's very interesting and the patent office, they're dealing with cutting edge technology that probably only the inventor understands and knows. So
yes.
It's very natural that they're really struggling to this is a very hard job they've set themselves out to do when they try to regulate new technology, because it's by definition unknown to most people, right?
Exactly.
I also know that there's the strategic of submitting prior art to the patent office. Say that you have your patent. You have a portfolio of patents in your area, but there's also stuff that that you probably couldn't get a patent on, but you want them to know that it's there and that it's prior art. Could you talk a bit more about the formal process of providing prior art to the patent office?
Yes,
there is such a process.
There is such a process. It's not very widely used. And I think the reason is there's a little bit of a distrust that the patent office will adequately appreciate that piece of prior art, and more entities want to sort of reserve that as a quiver that they can use at a later date. And so we have, on behalf of some clients, submitted some prior art during prosecution of a competitor's patent. And the problem is that if the examiner doesn't appreciate it and issues the patent, then you can't ever use that prior art again.
Okay.
So some people if you submit it and the examiner agrees with your comments and the applicability of the art, then maybe you will prevent the application from getting granted. But it also gives your competitor an opportunity to perhaps draft claims around it and get a patent, albeit a few months later than they would have otherwise. So for the most part, though, we stockpile that prior art. And use it when in other procedures before the patent office, or use it in negotiations. If that person with the patent comes to you with the letter, we might use it in negotiations.
Yeah, because that says, and that's also representing your particular client, I guess. If you know this, and then you can have that as you say, as a quiver. So now we have a U.S. patent. And we think our idea is great. Everyone's going to want it. They're also going to want it abroad.
Yes.
Say we have a certain provisional filing date, and we're then thinking already now of what we do abroad, because our investments realize that the world is a big market. How do we do it? What's the timeline? What's the specific? I mean, I guess the application has to be translated to different languages, but the application as such is the same, or does it have to be adapted to different countries, different rules and regulations?
All very good questions. First, let me address the timeline. So you do have the 1 year time bar is a deadline for getting applications on file, a utility application on file in the US, and also for applications in other countries. So that's the argument also for not waiting till the 1 year deadline, because if you're going to file abroad, you really should plan that at least a month before the 1 year deadline. So what would I counsel clients to do? The law does vary a little bit from country to country, and we do if we know up front that you want to file in different countries, we will draft the application with those other countries in mind. One big market, for example, is Europe, and the drafting styles between Europe and US have gotten closer in recent years. But we do have an office in London with European patent practitioners, and we would we would run the application by our European practitioners and see if they think we should add anything. We do have an office in Shanghai, and we don't practice Chinese law there, but we would consult foreign consultants if you want to file there to see if it meets qualifications before we file it the 1 year mark. One cost-saving measure that we use quite frequently is called the Paris Convention Treaty, or a PCT application. A PCT application acts as a rest of the world placeholder. So on or before the 1 year anniversary, we would advise filing in the US and filing this international placeholder called the PCT application. What that does is reserve your right to file in the rest of all of the countries that are members of the Paris Convention Treaty, which is it's all of the developed world, pretty much. And that buys you an extra 18 months to decide which country you want to file in. And it buys you 18 months to get translations to the extent they're needed. It's not like the robotics community is filing in all the countries in the world. When we sit down with a client to devise a foreign filing strategy, we look at a couple of different things. You want to look at where will your technology be used, where will your technology be built, which is why China is often a source of place to file patents. Where are your competitors, and where does the country have a good patent enforcement, patent granting system? So that does limit where most companies tend to file. I have to say that for most of the clients in the robotics field, we're only filing in about 5, 6, 7 jurisdictions.
And then we're talking US, Canada, Europe.
Yeah, we're talking about US, Europe, China, Japan, Korea, software, sometimes India, Canada, Australia, the countries that make it very easy for us to file in and that have large markets in terms of potentially users of the device, and people that have manufacturing facilities. Those tend to be where we file.
So it is in that handful or two handfuls of countries we have to address, and that's manageable for even a smaller company.
It's manageable, but the costs can easily mount up. If you were to file in 10 jurisdictions, the filing fees alone will probably be $50,000 because of translation costs and the independent countries' own official filing fees to the individual patent office.
Yeah, that starts to be a significant cost, and that's in the deadline would then be 2.5 years after our first U.S. Application.
Right, which is why the PCT allows a company to spread out their costs. If you file at the 1-year mark in the U.S. and you file the PCT application probably will cost you I don't know, $2,000 to $4,000. And the reason I can't be more exact is because it depends on how many claims, it depends on the length of your application. There's a per page fee in both countries and a per claim extra fee, so it varies. But once you file the PCT, then your fees to these individual foreign patent offices, you wouldn't have to pay them for another 18 months. So it allows you to spread out the fees.
Yeah, and also maybe acquire more funding or
Yes.
simply see if the idea is something you'd like to carry on with.
It's a good point. A lot of clients that are working their way up, they file in the provisional, they file in the US and the PCT, and then they enter that 1.5 years where they see whether their technology is going to take off and whether they're going to get acquired, whether they're going to just gain speed as a company.
And also you can do all the preparation work and then really push the final formal application towards the end of that period. If all your work is done, the filing can be done towards the end of the period too.
Well,
which is the filing fees for all these countries do add up too. Huh?
They do, but the filing that we would do into the individual countries is administrative because we file a carbon copy of the PCT application. We cannot add new matter or else there would be a new priority date. So all the drafting has to be done and the most attention has to be paid to that utility application that is drafted, at least 1 month before your 1-year filing date.
I think that something that a startup really has to think about is the timeline here. There's a lot of dates to keep in your head and not make a mistake and thinking it was next month, because that could be very expensive. I think that in the team there's probably supposed to be somebody that takes care of this so that it doesn't get dispersed among the team members too much, because there's a lot of dates to keep in mind. Say then that the company becomes a success, either it's acquired and then that's somebody else's problem, but we grow this company ourselves. Is there any further dates when my patent starts to expire? Do I have to renew it? Do I have to work with my patent after it's been granted?
Well, yes, the U.S. has a mandatory maintenance fees at the 3.5, 7.5, and 11.5 marks of a 20-year term. And you do have to pay those in order to keep your patent in force.
And how much are the fees in general?
I want to say,
just roughly.
Yeah, $1,700 or something like that. I don't know exactly.
But in the couple of $1,000 range.
A couple of $1,000s. Now, European countries and some other countries do it differently. They charge you an annuity every year, but the annuity is smaller. The annuity might be a couple of $100, and it might be constant over the 20-year term. In the U.S., the maintenance fees do get more expensive as you go. The 11.5 month maintenance fee or 11.5 year maintenance fees is more expensive than the 3.5 year, which that's fine, because in this technology area, oftentimes people get a patent, they might pay the first maintenance fee at 3.5, and the technology might be obsolete, and so they don't pay the final 2 and they let it just be expired.
Because if you don't pay, the patent expires and it becomes public domain at that point, I would...
Exactly.
Yeah, so anybody could use the technology, and you couldn't even use it to defend yourself in a situation then, okay. So when does, I mean, say we pay all these fees, we work with our patent, and we're now approaching, when does it expire totally, so to speak? When
20 years from the date of the provisional.
Okay, so say
if you use a provisional, or 20 years from the date of the first utility filing if you don't use a provisional.
So that gives you then in theory 19 years or 20 years of patent. So that's also another time scale. Although, as you say, in a fast-moving technology world, I doubt that any technology would be significantly valuable 20 years from now. Although that can happen.
It could happen.
Yeah. Say that we're approaching the 20-year deadline here. What is our? I mean, this is not for the young startup, but who knows? Maybe this could be interesting to look into the future and prepare. So we are at year 18 or 19. We're approaching this. We of course have other patents with our running times too, but one of our main patents is approaching 20 years. What do we do?
Well, at that point, there's nothing you can do to extend the life.
No.
You might want to make sure that look around and see if anybody is making the product, because it is possible to enforce the patent even after it's expired. Because under statute you can get damages or money for people's prior use of your patent up to 6 years before the date that you tell them they're violating it. So it is possible for your patent to be expired, and then you say, oh, you've been using it for 6 years, I want 6 years of back pay, so to speak.
So say we've evolved our technology, and I guess what you have to look at over the duration of your patent portfolio is how do we use our patent in combination with it. We came with our first patent, it was our first idea, but we're always in the same domain because we have an expertise in a certain domain. So when we're finished with our first patent, we're already working on our second, our third, our fourth, and they all have different running times. How do we, being in this reasonably tight space, how do we build a patent tower where our increased understanding of the technology, our increased development of new technology, and our increased understanding of the customer's needs? How do we, because a company is not going to have one patent, it's going to have a portfolio of patents. How do we make a good puzzle there?
Well, it's exactly the way you said, is as soon as you want to file that provisional as soon as you have a good core of ideas. But then you want to file subsequent provisionals or subsequent utility applications building on the idea. So any time that your team comes up with a new development, that would be a good time to contact the patent attorney or sit down and think about an additional application. And it is, it's good for a company as it grows to build this culture of understanding of IP, and that as soon as we have an idea that is formed well enough that we can recreate it and talk to somebody about it, we should be thinking about how to protect that and adding to the portfolio with another application. And
also adding the prior art tool that could be available to us in the future when somebody thinks about something, add it to the process so that if we get into trouble, we have that stored in some formal way so that we can access it.
Yes.
We talked about the patent process from a starter perspective, and that means we talked about the first time somebody does a patent. Right. Is there anything, say that we have these patents, do we have to relate a new patent we're doing to the old stuff? Could we tie them together? Should the claims be matching, or is there anything there we think of when we do a second or third or fourth patent?
You don't have to, and most companies, as they grow, they will have, we call them families of patents that are related, but they don't have to be related. And sometimes there's a family of patents related to the hardware, and a family related to the software, and a family related to the mechanics or something. So they don't have to. The one thing to pay attention to is there is a duty to disclose to the patent office prior art that you know about. And if you do not disclose the prior art, if you somehow hide it, it could make your patent unenforceable. So what we do a lot of is when we're working for one client, we keep track of the prior art that one examiner has used against, say, an application in this family, because we're presumed to know about it, and then we make sure that the examiner in this family knows about that prior art if it's relevant, so that there's no issues down the road that we knew about a piece of prior art and we hid it from the other other examiner. So that we call that cross-citing, and citing, that's an information disclosure statement is the official term for the notice that we give to the patent office of the prior art that we know about.
And of course our own patents is of course our known prior art to ourselves. So if we are patenting an idea that is close to one of our own patents, we're presumed to know that exists, because it's of course hard for the process to know what we knew at a certain given time. That's not easy, but our own patents we're supposed to know, right?
It can be, yes. It can be prior art against another patent in your own family.
Yeah, and I guess you've advised the client on how to structure the patent so that they kind of fit together, and I guess that's somebody further down the line for a startup that's not going to be very relevant, because they're struggling to do a one or two or a few patents rather than to build families.
Well, if we are consulted early in the process for even a newer company, that's one of the things we would do. We would sit down and create an outline of all the patentable aspects of the invention, and we might group them, we might prioritize which ones we want to get issued first. If money's an issue, we want to maybe file these first, file these later. And it will depend on which patents might be more attractive to investors. Maybe which ideas that we think somebody else might copy or something. There's a whole lot of strategy into which ones we pursue if budget is an issue.
One patent might be in a very crowded patent environment. One might be in a deserted environment where there's not many patents, and that could also play in. So to summarize this for a startup, it is contact you early. Look at the calendar. There's lots of dates to do, and that the cost ranges from a few $100s to a few $1,000s, and up to a worldwide patent would be in the $50,000 range, so to speak. Of course, this has many variables, but this just so that they have some form of a basic knowledge of the area. Is that true?
I think your best advice is to contact us early, or contact a patent attorney early. I think we can lay out for you very easy what the timelines are, what the pitfalls are, give you a roadmap for what you need to do and when you need to do it to make sure none of that is missed. I think I just worry that, and don't be afraid of the patent attorneys. I mean, we are all, at Finnegan anyway, we're all former engineers. We've been in your shoes. We decided to go over to the dark side and get a law degree, but it's because we want to add that legal component to our engineering expertise and assist engineers in getting their inventions patented. But it's only if we are contacted early that we can always help you even later, but then it becomes more strategic might need to correct a few things, there might be some things missed.
Unnecessary complications.
Unnecessary
costs maybe, and also a less valuable patent in the long run.
Exactly.
And also maybe doubt in the investor community of if this is going to work out.
Absolutely.
So, thank you very much. I hope that the startups there really take this to heart, and that we're going to see a great number of patents coming out. And this is also important for the long run. When the patents expire, they become public domain, and everybody can use the technology and benefit from it. So the patent system as a fundamental structure is very important for just society.
Exactly.
Thank you very much. This episode is sponsored by Aptomica. Everything you need in modular robotics. Or robots up close, what's going on in robotics, online and on the road. If you like this interview, don't forget to subscribe, follow us on Twitter, and subscribe to our email newsletter on robotsinDepth.com. You can also support the show on Patreon. I would like to thank the organizers of RoboBusiness US for their help when I recorded this interview.